Okay, good morning, ladies and gentlemen. Welcome to the Business Rescue webinar. I see it's a minute past 9, so I think we can start. I'm Professor Loubser, and I will be conducting this workshop today and tomorrow. I think let's first have a few housekeeping rules. First of all, please make sure that you have all switched off your video cameras. It's not that I don't want to see you, but the moment the videos are on, the quality of the sound suffers and then you can't hear me. So secondly, please mute your microphones. We don't want any outside noises interfering with the workshop. Yeah, I can still hear people, so please make sure your microphone is muted. What we're going to do today is we are going to right, let me just see. No. Oh dear. Have I now? Okay, no, that's fine. Okay. I'm not going to switch on my video either because, as I say, it affects the sound, and also you will find that my Wi-Fi just can't take video and sound. So let's rather keep to the sound. That's the most important thing. Right. So from now till 11 o'clock, I will basically take you to more or less the first half of the work. We'll have a short comfort break at 10 o'clock, just for 10 minutes or so. Then I will carry on until 11 o'clock. And then if you have any questions, I will give you the opportunity to ask questions. If you want to ask a question, please don't use the chat function. Put up your hand. You see that little hand at the top of your screen, and wait until I identify you as the person who can now ask a question. Then you unmute your microphone, you ask the question, and once I've answered your question, then remember to mute your microphone again and also take down your hand so that I can see you're not waiting in the queue anymore to ask a question. Now I'm going to, as we go along today and tomorrow, I will mention a few new judgments that are not in your textbook or your study guide. Don't panic. There is a tutorial letter 103 on the way. I'll probably upload it on my UNISA at the end of this week, in which I give you the details of all the new judgments that are important and that you are expected to know about. Then let's see. Also, I'm not going to discuss the assignment because you've got your tutorial letter 102 in which we tell you what we were expecting you to do and where some of you went wrong. All I want to say about this is that some of you ignored our very clear instructions not to quote directly from the ACT or the study guide or the textbook, and as you would have noticed, you got no marks for that. You always have to do or use your own words to show us that you actually understand what's going on and what especially in the case of the ACT, what the provision means. Also, some of you still used footnotes. In the exam, when we're marking the exam questions, we're under a lot of pressure to finish. So we do not have the time to check footnotes as well. So if you have information in your footnote that would have earned you a mark had it been in your text, you're going to lose that mark because we don't give marks for information contained in a footnote. So please don't use footnotes. In any case, you always have to, when you state a principle, a legal principle, you have to tell us where it comes from, that you didn't just think it up yourself, but that it's in the ACT or in a judgment, etc. So it has to be part of your answer. Also, once again, please follow our instructions. It's in tutorial letter 101. There will be some again, basically a repetition in tutorial letter 103, and then also at the top of your exam paper, when you get your exam questions, you will see that we have a list of 7 or 8 or 9 instructions. Please read through them and follow them. Otherwise, you are going to prejudice yourself. The other thing is, remember that this exam is referred to as a portfolio. You will see that on My UNISA when you submit. It's referred to as assignment 2 and then portfolio. So when your final marks are released on My UNISA, please don't send panicked emails to say, my UNISA record says I was absent from the examination. I was not absent. I did submit my exam answers. You were all absent. You will all be absent from the examination because there is no examination. There is only a portfolio. So the portfolio mark is the mark that you got for your exam answers. Okay, so don't worry about that. It doesn't mean that we didn't get your answer. Then make sure you have access to the internet and to My UNISA during that weekend of the exam. Please don't wait until the day when the questions are released on the Friday and then find out there's something wrong with your access to My UNISA. If you have problems, please contact Ms. Mafolo. Don't contact me. I can't help you because I'm not employed by UNISA. I have no access to their internal system. So contact Ms. Mafolo immediately because UNISA is very strict about the fact that we are not allowed to accept exam answers by email. It must be submitted on My UNISA. Okay, I think that's about it as far as the exam is concerned. Your assignment questions will give you an indication of more or less what sort of questions you expect. Question 1 was taken directly from an exam paper. Question 2 was a simplified and shortened version of an exam question, but that's the type of questions we will ask. In other words, you mustn't expect to be able to just give us the law and that's it. We will test your insight. We will test your ability to apply the law to practical problems because this is supposed to be a course for people who want to work with business rescue, either as a practitioner or to advise clients, etc. And I can tell you, I read a lot of business rescue cases, and the degree of or the lack of knowledge of some lawyers, advocates as well as attorneys, I won't say the judges, but I'll whisper that, is really stunning. It's staggering, it's shocking, and it is your task to make yourself familiar with the law, to see how it works in practice, to be aware of the problems so that you are able to do a proper job when you are involved in a business rescue case. Right, so obviously because it's open book, you will have all your study material with you and you have 4 days in which to answer the exam questions. We are not testing your memory, we are testing your knowledge to a certain extent, but we are specifically testing your insight into the law and also your ability to apply it to practical problems. So please don't underestimate the degree of preparation you have to do for the exam. You can't just quickly look up the answer when you're answering the exam questions, because many of the exam questions involve topics from different areas. So if you don't know the work well enough, if you haven't gone through the work properly, you won't even recognize the problems or the issues that are raised in the question. So you must know the work fairly well. You don't have to memorize all the details because you can look it up, but you have to have a very good idea of the contents of this course. Also remember, your answer must be taken from your textbook, the ACT, or the study guide, or of course the tutorial letters. Don't go surfing on the internet to try and find answers. You won't, apart from the fact that you will probably get the wrong answers, you will not get any marks for information that doesn't come from your study material. Everything you need to know is in your study, in your prescribed study material. That's all you need to use. Okay, I think that's about all that I wanted to say about the exam. Our time is limited, so I don't want to waste too much time anymore. I'm going to start on study unit 1. I will obviously not cover everything that's in your textbook and study guide, but I will try to at least highlight problems and issues and of course updates where something happened, where there was an important judgment in the meantime. The Supreme Court of Appeal has been very busy, so we have quite a few extra judgments, but I won't burden you with too many, only the important ones. Okay, study unit 1. I think the possible issues there. First of all, remember that the Act defines rescuing the company. And it defines rescuing the company as achieving one of the goals or objectives in the stated in the definition of business rescue. So you'll see that although hearing the words rescuing the company sort of implies that the company is going to survive, or of course the closed corporation, because I'm sure by now you know that the business rescue provisions are also applicable to closed corporations. In actual fact, in terms of the objectives stated in the definition of business rescue, there are two objectives. The one is actually rescuing the company, in other words, returning the company to solvency. But the second objective or goal is that you get a better return for creditors than would have been the case in an immediate liquidation. So basically that means the company is going to be liquidated eventually, but because of business rescue, you think that you are convinced that you will get a better return for your creditors by, for instance, selling the business of the company or parts of the business of the company as a going concern. In the case of mining companies, for instance, if the company goes into liquidation immediately, it loses its mining license, and a mine without a license is not worth much. So there are various reasons why possibly business rescue will give you a better return. And you will see that in the textbook we point out that originally some judges were not too happy about the second objective, and they refused a business rescue order where the applicant indicated from the start that this company was not going to be rehabilitated and rescued, but based it on the second objective, that it would give a better return for your creditors. And the Supreme Court of Appeal in the Oakden case made it clear that you can actually apply to court for a business rescue order on the basis that it will give you a better return for your creditors right from the start. So you don't always have to first try and actually rescue and rehabilitate the company. You can actually from the start pursue the second option or second goal, which is to get a better return for your creditors. Then I just want to point out on page 265 of the textbook, the paragraph that starts with section 1281A lists the so-called affected persons. And then it says there, these are the shareholders, and then in brackets, pre-commencement creditors. Unfortunately, that is actually not so clear from the Act. The Act does not contain a definition for creditors. The draft bill at some stage did, but it was such a bad definition that they had to scrap it. So we don't really know whether they only wanted to include pre-commencement creditors, in other words, people who had a claim against the company at the commencement of business rescue, or whether post-commencement creditors should also be included. I have always firmly believed that they only wanted to include pre-commencement creditors for various reasons. You'll see when we get to the contents of the business rescue plan in section 150, it only requires you to include pre-commencement creditors. So post-commencement creditors are not listed in the plan. Section 154.2 states that the plan is only binding on pre-commencement creditors. In other words, only persons who had a claim against the company before commencement of business rescue may not claim that amount from the company, except in terms of the business rescue plan. It doesn't say that about post-commencement creditors, because obviously they contract with a company that's already in business rescue, so they have to protect themselves contractually. They don't need other protection. And it seems, as far as I'm concerned, rather unfair to allow post-commencement creditors to vote on a plan to which they're not bound. So, but you will see right at the end that not everybody agrees on that, so we'll have to see what happens. There are strong opinions on both sides. I listened to a webinar of Saripa the other day, where a senior counsel said, in his opinion, it's only pre-commencement creditors and the cut-off date is the date of commencement. But I know that Professor Delport, who is the writer of Hinoxburg on the Companies Act, believes that every creditor is a creditor up to, he isn't quite clear what the cut-off date would be, but I suppose the cut-off date would then be the date on which you finalize your rescue plan, because you can't keep on changing your business rescue plan to include more and more creditors as they appear. Okay, so just keep that in mind, that maybe it's only pre-commencement, maybe it's all creditors also post-commencement. Right, so I think that is all I want to say about study unit 1. Remember to look at the definitions. As you can see, they are very important. Oh, the other definition you must just keep in mind is that there is no definition of a company in Chapter 6, but there is a definition of a company in Section 1 of the Act, and you'll see that only companies incorporated in South Africa are included. So you cannot put a company that was registered in another country, in another jurisdiction. You cannot put that company in business rescue, which is one of the reasons why Steinhoff, the holding company, the bigger company, could not be put into business rescue, because it's a Dutch company. It's registered or incorporated in the Netherlands, so it doesn't meet the definition of a company in terms of the 2008 Act. However, external companies or foreign companies, companies that are registered in other jurisdictions, can be liquidated in South Africa if they have a business in South Africa. So you can liquidate them, but you cannot put them into business rescue. So that is also something to keep in mind. There was a recent case, which is not important, because they were just sort of taking a chance just to make quite sure that they couldn't put this company into business rescue. I think the company was registered in Italy, and the court was very clear to say that a company registered or incorporated in another jurisdiction in another country is not included in the definition of a company for this purposes of this Act. So sorry, no, you can't put this company into business rescue. Okay, so study unit 2, starting at paragraph 12.3. There is something very strange. Okay, let's make this clear first. There are two ways, I'm sure you know that by now, two ways in which you can commence business rescue or place a company in business rescue. The first one is by the filing of a board resolution with the CIPC. The second way is by applying to court. Now, there are important differences between the two. First of all, commencing business rescue by way of a board resolution. Some people still refer to that as an application to the CIPC. It's not an application. The business rescue commences when you file that resolution with the CIPC, but it's not an application to the CIPC. The board doesn't have to ask anybody's permission to commence business rescue by way of a resolution. They just file, they have to file this resolution with the CIPC, otherwise it is of no force and effect. The application one is the other possibility, and that's where an affected person may apply to court for a company to be placed in business rescue, a company or a closed corporation, of course. So the board cannot apply to court. If they don't take the resolution, then somebody else has to apply to court. So that's the only time when you talk about an application, because the court has to grant your application, grant the order placing the company in business rescue. So don't talk about an application to the CIPC. It is just the resolution that has to be filed. Now, as far as the board resolution is concerned, there is a strange, a mystifying provision, as with so many other provisions in this Act, that doesn't quite make sense. In paragraph 12.311, you will see the board of directors of a company may take a formal decision. In other words, this decision, this board resolution must comply with all the requirements for a valid board resolution. In other words, it must be taken by the majority of directors. All directors must be informed about this meeting where the resolution will be taken. It must be a valid board resolution. It then says, a business rescue resolution may not be adopted if liquidation proceedings by or against the company have already been initiated. Now, this one provision in section 129(2), it contains two problems. So that's quite a record for any legislation. First of all, it says that the board may not be adopted if liquidation proceedings by or against the company have already been. Now, why do they use the word adopted? Because section 129 states quite clearly that the board resolution is of no force and effect until it has been filed. And yet they say the mere adoption of this resolution means that you cannot start they cannot apply to court. I'll get back to that when we get to the application to court for a business rescue resolution, but it doesn't seem very logical that a resolution is of no force and effect, and yet once it's been adopted, then the liquid, you cannot go to court. But actually that goes under the application procedure, so I won't confuse you further with that. We'll talk about that later on. But it is strange that they talk about adoption of a resolution when the resolution only becomes valid once it's filed. But anyway, okay. The other problem is if the liquidation proceedings by or against the company have already been initiated. That's your big problem. You'll see that there's one case in the textbook, First Rand Bank versus Imperial Crown Trading, where the court said, we don't know what initiated means because it's not a legal term and it's not defined in the Act. So we must assume that it means the same as commence, which is defined in Chapter 14 of the 1973 Companies Act, which still applies to the liquidation of companies. I'm not sure if that was what they intended, because they do use the words commence in other instances. So initiated to me seems to imply that they had something else in mind. But what that is, we don't know because they don't tell us. In your study guide, you will see that there have been a number of judgments on this point, and they all disagree on what initiated means. The one said, well, it means it's something that happens before formal commencement of liquidation. Others say no, it's later on. Your liquidation must be served on the company. It's a later stage. And then the most recent case actually agreed with FirstRand that we must assume that initiated means the same as commence. And as you will see in that footnote, liquidation proceedings commence when your papers, your application are issued out of court. And that means when you go to the office of the registrar of the High Court with your application and your supporting affidavit, and you give it to the clerk behind the counter, and he or she stamps it with a date, that and returns and gives you a case number, yes, a case number, and then hands back the documents, then you have actually commenced. Your application has been issued out of court. So it's very specifically defined in the Companies Act of 1973, which still applies to insolvent liquidations. So we don't know. We still don't know because we still don't have a Supreme Court of Appeal judgment on this. So it could be sometime before formal commencement of liquidation proceedings when the first steps are taken. It could be the same as commencement of liquidation proceedings, or it could be later on once the application when the application or resolution is served on the, or served on the company. So because we don't really know, so we're guessing just about any at this stage, any opinion will be fine. So initiate is a problem, or rather the meaning of initiate. Right, so liquidation proceedings then must not have been initiated, whatever that may mean. So it's one stage or the other, hopefully we'll get some certainty on that. So that's the one problem we have there with the initiate, what it means. Then in your study guide, we also mentioned De Bruin versus Conradi, where the court held that a shareholders agreement that required approval by the shareholders before the company could apply for a judicial management order. So that was long before Business Rescue and the 2008 Companies Act was introduced. We think that's probably wrong because judicial management could only be done in one way, could only be commenced in one way, which was to apply to court. So there it made sense that your shareholders must be informed, or that they can give their consent or refuse it. There wasn't even certainty whether the board could apply on behalf of the company. But Business Rescue is something completely different. The Board of Directors has been specifically given the authority to commence business rescue by way of a resolution without having to consult anybody, the shareholders, creditors, whoever. And if you now require them to first get the permission or the consent of your shareholders, you are in fact taking away from that statutory right or authority that they have to commence business rescue. So I don't think you can do that. I don't think that's valid. We haven't had any other case where that was decided. So I don't think you can do that. You cannot, in your memorandum of association or in a shareholders agreement, require your board to consult the shareholders or get their approval before you file a board resolution to commence business rescue proceedings. Right, I think that was really the points I wanted to make in study unit 2. Let me just see. Okay, you must take note of section 129(7), which states that if the board has reasonable grounds to believe that the company is financially distressed, it has to either take a resolution to place the company in business rescue, or it must notify all the affected persons that the company is financially distressed, but they have decided that they're not going to commence business rescue proceedings. Now, obviously, that would not be a very good idea to send out such a notice, because your creditors will then immediately know that you can't pay your debts, and they will immediately start trying to get first in the queue to demand payment and get paid. So I don't quite know whether the drafters of the legislation actually considered the consequences of sending out such a notice. All I can tell you is that nobody does it. I know of one case where a company sent out such a notice, but they did that on purpose. They wanted somebody to apply for liquidation of the company because the company itself didn't have the funds to pay for a liquidation application. So they knew if they send out this notice, some or other creditor is definitely going to apply for the liquidation of the company, which indeed happened. And so the company was liquidated and they didn't have to pay the costs. Setting aside the resolution, let me just see. Okay, I'm not going to go into the non-compliance issue and Panama Properties versus Nel, because that was in your assignment. That was part of your assignment question. I think it's an open secret that I think Panama versus Nel was a huge mistake, and we've already seen people, companies abusing that. Recently, there was an instance where a company filed a business rescue resolution. They appointed a practitioner, and it turned out that this practitioner no longer had a valid license. His license to act as a business rescue practitioner had expired, because the license is only valid for 3 years. So he was not licensed to act as a business rescue practitioner. The CIPC informed him and the company about that and said, we need the following documents so that we can renew your license. Their notices were ignored, so this person just carried on acting as the business rescue practitioner, eventually even had a business rescue plan approved. And as you know, in terms of Panama versus Nel, once a business rescue plan has been approved, it's too late. You cannot have this resolution set aside anymore. So basically, this company was the business rescue procedure of this company was done by somebody who was not a licensed business rescue practitioner. When the CIPC objected, the company simply went to court and got an order from court based on Panama versus Nel to say, sorry, this company is in business rescue because non-compliance does not make it invalid. You have to apply to court to have the resolution set aside. Nobody did. The plan has been approved, so it's too late. I don't think that the court actually considered the issue very properly, because I think this is more having a non-licensed person acting as a business rescue practitioner is not just a non-compliance with a formal requirement. There was no business rescue practitioner. But anyway, 18 months later, it was too late because the plan was approved, and this unlicensed person, knowing that he was unlicensed, simply carried on, and now they say they can't do anything about it. So that is a serious abuse. I hope he gets scrapped or thrown out of his professional organization, because he was obviously quite aware of the fact that he was acting in contravention of the act. But I don't know. Right, we've talked about delivering the notice. Setting aside the business rescue resolution or appointment of the practitioner, as you now know, in terms of Panama versus Nel, you have to, well, not just in terms of Panama versus Nel, the Act says you have to do that before business rescue plan is approved. So if there's anything wrong with the resolution or the grounds for the resolution or the business rescue practitioner, you have to, as an affected person, apply for the resolution to be set aside or for the business rescue practitioner to be removed before a plan is approved. After that, it's done. In Panama versus Nel, which was again quoted in the Lange versus Martens case, the court said, after approval of the plan, all flaws in the procedure are historical. They are not important anymore. There's nothing you can do about it. This business rescue is valid and it will carry on. Also, if you want to have the business rescue practitioner give security for the proper performance of his task, you have to apply to court, which is really an indication that the drafters of this legislation knew very little about South African law. They were not actually South Africans, because in all other appointments, as an executor, as a trustee, as a curator, the first thing you have to do is to give security for the proper performance of your duties. And if you don't, then they won't appoint you. But in this case, you get appointed as a business rescue practitioner. You walk into a company, take over the management of the company, or at least the management must listen to your instructions, and you don't have to give security if you make a total and complete mess of it and the company suffers damages. So the King Code of Corporate Governance, I think it was the third one, third King Code said that any board of directors in exercising the proper care and skill and their fiduciary duties should insist on a business rescue practitioner giving security for the proper performance of his or her duties before they appoint him or her. So you can insist on it, but if you don't, then the business rescue practitioner gets appointed without giving any security, which is a huge risk for the company. Now, have a look at the grounds for setting aside the appointment of a business rescue practitioner. You'll see later on that there is another section in the Act that you can also use to remove a business rescue practitioner. That's section 139. We'll get to that eventually. But the difference is that you can only use section 130 to remove your business rescue practitioner until your rescue plan has been approved, and then you can't use it anymore. The other section, 139, you can use either before or after approval of the plan, so it doesn't matter. So you can use it right through the procedure. Also, the grounds in 139 are wider than the grounds set out in section 130. Interestingly enough, you can apply for a business rescue practitioner's appointment to be set aside because he or she lacks the necessary skills for the company's circumstances, but it's not a requirement for appointment of a business rescue practitioner that this person must have the necessary skills and experience for this particular company. So that's on the board of directors. They have to make sure that the chosen business rescue practitioner actually knows what he or she is doing. Also, the other difference is you will see that if you apply to court under section 130 for the appointment of the business rescue practitioner to be set aside, you'll see that in subsection 6, the court must appoint an alternate practitioner who satisfies the requirements, etc., recommended by or acceptable to the holders of a majority of the independent creditors' voting interests. Now, that doesn't quite make sense because the applicant could be a shareholder. How would he know who the independent creditors are? So apparently, if they don't object and somehow join the action, then the person making the application can actually choose the new business rescue practitioner. But it is actually it will be the applicant who will nominate or indicate a business rescue practitioner, and then the court will appoint that person. You'll see in section 139 that it is actually, if it was a voluntary business rescue, in other words, the original business rescue practitioner was appointed by the board, they are the people who can choose who will be the next appointee. So the people who appointed a bad business rescue practitioner or an underqualified business rescue practitioner, in the first place, they get the chance to appoint somebody again, which obviously is not what you want. Right. I think that was basically what I wanted to deal with there. The rest you will find in your study material, so I don't think I need to go through that again. Study Unit 3, that's the commencement of business rescue proceedings by order of court. Now there actually is the one where I have serious doubts about the use of the word adopted. Section 131(1) says, unless a company has adopted a resolution contemplated in section 129, an affected person may apply to court for an order to place the company in business rescue. Now, as I've said, in terms of section 129, a resolution, a board resolution, is of no force and effect until it has been filed with the CIPC. So what if the board adopts a resolution to place the company in business rescue, but for some reason they don't file this resolution? Nobody is going to know that this resolution has been adopted. It's been kept in somebody's bottom drawer of his desk for whenever they are ready to file. Now, an affected person goes to court and applies for a business rescue order, and all of a sudden, the board jumps up and says, well, no, sorry, you can't do that because we have already adopted a business rescue resolution. Maybe you didn't know about it because it's not been filed, it's not been served on anybody, but here it is, and you'll see the date. The date was before you applied to court for the business rescue order. So that doesn't make sense. An adopted resolution should not have any effect. It should only be relevant once it has been filed with the CIPC, because then it has to be served on the company, and the company will know about it, and your affected persons will be notified, so they will also know that such a resolution has been taken. But the mere adoption of a resolution will not be known to anybody else, and it has actually now happened in one case where the board took a resolution and there were all sorts of delays, and not all of them due to the board, but and a creditor or a shareholder, no, it was a creditor, applied to court for a business rescue order. And now the question is, because the court obviously doesn't know about this resolution either, because it hasn't been filed with the CIPC, whose business rescue is this? Is it the one that is commenced by filing of the resolution or the application to court? And it's an important issue because it's all about control. If the business rescue procedure is started by a board resolution, then obviously the board has the power to appoint the business rescue practitioner of their choice. If it is started or commenced by way of an application to court, the applicant has the right to nominate the business rescue practitioner, the interim business rescue practitioner, and what's more, the creditors can, at the first meeting of creditors, decide they don't like this business rescue practitioner, and they can in fact refuse to ratify his or her appointment and appoint somebody else. You can't do that with a business rescue that's commenced by way of a board resolution, unless you go to court. With a business rescue resolution by order of court, you don't have to go to court to remove or get rid of this business rescue practitioner. You can just refuse to ratify his appointment or her appointment at the first meeting of creditors and appoint somebody else. That's the only time you can do that without going to court. So it is important for everybody concerned whose business rescue proceedings will be the relevant or the valid ones, because that will determine who gets to appoint or nominate the business rescue practitioner. I think it's going to go to court very soon, if not today. So we'll hopefully we'll see what happens and what the court decides on that. But anyway, that shows you that talking about adopting the resolution is not correct. It should have been when it's been filed with the CIPC. Right, the next question then was, Section 131.6, which provides that a business rescue application suspends any liquidation proceedings. So if the company is already in liquidation, you cannot file a board resolution, but you can apply to court for commencement of business rescue. And the mere application is enough to stop the liquidation proceedings right there in its tracks. The question then was, because it says, Section 131.6 states that it will suspend the liquidation proceedings. So the question was, what do they mean by liquidation proceedings? Do they mean the legal proceedings in court, that you cannot go ahead with your court application? Or does it only refer to what happens after the liquidation order has been issued, so that a court can actually continue with your application, grant the liquidation order, and then immediately suspend it so that the liquidators cannot continue with their work? Or does it include everything? And you will see after some differences of opinion, in the end, the court said that it can happen at any time, and that liquidation proceedings includes everything, including, as you will see in the one case, even the application for liquidation. If the court has not heard it as yet, even that is suspended. So everything is suspended from beginning to end as far as liquidation is concerned, and the liquidators cannot continue with the liquidation of the company. Now, the question now was, or the court refers to or the Act refers to the application suspending, the application for business rescue suspending the liquidation proceedings. So again, there was a problem. At what point of your application? So is it the moment your application for business rescue is issued by the registrar? In other words, where you get your date stamp and your case number, is that the moment of application where everything is suspended? The textbook mentions Standard Bank of South Africa versus Gas to Liquids, where the court held that the application has not been made, so it doesn't suspend your liquidation merely by having the application issued out of court. That's when the registrar stamps your application, because the liquidator may not even know that he or she no longer has the authority. So it's only after the application has been served on the CIPC, the company and the liquidator and affected persons have been notified that the application can be said to have been made. A more recent case that is mentioned in your study guide is the African Global Holdings versus Luchman, where Acting Judge de Villiers said that cannot be right, because in our law it is an accepted principle that an application is made the moment you get that stamped application document with a case number. That's when the application is regarded as having been made. The service on the company, on the CIPC and the company and the liquidator, that is a procedural issue. The Act did not intend to make any difference to the legal principle of when an application is made. But when the matter comes to court, that's when the court will have a look at your procedure to see whether the the application is properly before court. In other words, has it been served on everybody who should have been served, and has everybody been notified in the way required by the Act? So at this stage, we still don't know what the correct answer is, because again, we don't have a Supreme Court of Appeal judgment on that as yet, but the courts are not in agreement. At what point can you say that your business rescue application has been made and will suspend liquidation? I tend to agree with the African Global Holdings versus Luchman case. Our law is settled. An application is made when your documents are issued by the registrar of the court, and these other requirements are not legal, will not affect the legal position. It's just that it is a requirement that you have to serve your application and also notify the affected persons, but it doesn't make a difference to the basic principle of our law that an application is made the moment you've handed your documents to the registrar's office and you get it back with your date stamp and your case number. Then the question of what would be included in liquidation proceedings. As I've mentioned already, is it just legal proceedings, in other words, the court proceedings, or is it only the proceedings that follow after you've obtained the liquidation order? Would it cover everything? And after some uncertainty and conflicting opinions, in the end, the Supreme Court of Appeal stated that in Richter versus Absa, that at any point in your liquidation proceedings, so it covers everything in liquidation. The moment there is an application for a business rescue, your liquidation proceedings are suspended, irrespective of what stage they are at that point. From the application for liquidation itself, right up to the point where the final liquidation and distribution account has been approved and the company has been dissolved. So up to the point where the company has been dissolved, just before it gets dissolved, you can actually suspend the liquidation proceedings by an application. So at that point, when you make the application, nobody knows whether it's just an abuse of the process just to stop the liquidation, or whether it is actually a solid application. That will only happen once the application is heard by the court, and that could be months later. So, of course, then you have this vacuum. The liquidation proceedings have been suspended, but there's no business rescue practitioner to take over from the liquidators. What happens now? We had a few cases there. We have the Janssen van Rensburg versus Cardio. That's in your study guide, where the court said that although the liquidation proceedings are suspended, that only means the liquidators cannot continue disposing of assets and dividing the proceeds to creditors, but their appointment is not suspended, which means that they are still responsible for the estate of the company, and the directors cannot just take back the company, the management of the company, and say, well, sorry, liquidation proceedings are suspended, so you cannot continue, you are no longer in charge. The court said, no, it doesn't work that way. Then we had that very strange judgment of Maroos, where in the Gauteng Pretoria court, where the judge obviously realized that there was this vacuum, who's in charge now, and then said, well, actually the directors can take back basically their company from the liquidators, but there must be a manager who would be the intended business rescue practitioner, and he must now manage this company. Now, there's nothing in the Act that gives any court the authority to appoint such a manager. So it went on to the Supreme Court of Appeal, where fortunately the Supreme Court of Appeal made it very clear it's only the proceedings that are suspended. They're not cancelled, they're suspended. And that means, although the liquidators cannot continue with the liquidation of the company, they are still in charge, they are still appointed, and they are still responsible for the company in this period. So that means that the liquidators can still, for instance, oppose the business rescue application, and if a section 417, 418 investigation into or examination of the companies was started before the business rescue application started, because that's usually when the directors decide, or somebody decides, we better stop this liquidation before they uncover all sorts of details we don't want people to know about. That process can actually go ahead because the business rescue has not been cancelled. And the business and the liquidation has not been cancelled, and the liquidators still have the authority. They are still in place, but they cannot continue with the liquidation of the company. That was the Miller versus Becker case. I think that makes sense. You'll see on page 274 of your textbook, there's also a reference to taboo trading case, where it also said the business rescue only commences once the application has been lodged with and issued by the registrar and it has been served, etc. That is actually another problem, because if your business rescue commences whenever, whether it's when the application has been issued by the registrar, the court papers, or whether it's after you've notified everybody, there's still no business rescue practitioner around to take over from the directors. The business rescue practitioner only gets appointed once the court issues the order, grants the application for commencement of business rescue to start. So who's going to take charge of the company? Are the directors still in charge, or who's in charge? So you'll see that the courts have never actually stated it clearly, but they have sort of gone around this in most cases by sort of assuming that actually business rescue by way of an application to court will only commence once the court orders commencement, because you cannot have a business rescue proceedings without a business rescue practitioner. You have to wait for the court to issue the order and then also appoint your interim business rescue practitioner. The grounds, I think they are fairly clear. The courts have now more or less sorted out the matter, including the initial doubts whether you can commence business rescue proceedings when the company is already insolvent or unable to pay its debts, although the definition of financial distress refers to future insolvency in the next 6 months. And the court in Oakland Square Properties, which was the first Supreme Court of Appeal judgment on business rescue, where the court said if a company is unable to pay its debts, it qualifies for both business rescue because it's financially distressed, and liquidation because it is unable to pay its debts, and it will actually depend on whether there is a prospect of rescuing the company. Then you go for business rescue. If not, then you go for liquidation. The courts have repeatedly warned against the abuse of business rescue to simply achieve a liquidation, but without the oversight of the master, without a liquidator being, well, there's more control in a liquidation, and you can have there are many provisions that are not applicable to business rescue, such as Section 424 of the old Act of the 1973 Companies Act, where somebody where a creditor can actually hold anybody responsible who or liable who is responsible for the non-payment of his debts. You cannot do that in business rescue. So there are all sorts of advantages for people to abuse business rescue to achieve what is basically a liquidation, rather than go the official or regulated route of a proper liquidation. the courts are not happy about it when companies try to do that, but it is actually the act that has made it possible because of the second objective of business rescue, which is to get a better return for creditors, because it's a difficult thing to prove that this is not actually going to be the case. The courts have at least now said that they want there must be a prima facie case. Now, the requirements for commencement of business rescue proceedings are the same, irrespective of whether it's done by way of a board resolution or an application to court. The difference is that nobody checks whether the company actually complies with these requirements when the board submits or files a business rescue resolution. It's only if somebody takes the company to court to say, well, it did not comply with the requirements, then they are investigated. But not many people are prepared to take that, undertake that process, because it's going to cost you a lot of money and there's no guarantee you will succeed. Which then is the reason, among other things, that 91% of all business rescue cases are commenced by way of the filing of a board resolution, or then in the case of a vehicle. Now, what's the word I'm looking for? A closed corporation, a resolution by the managing members. So 91% of all business rescues are commenced by way of the filing of a resolution, because there is not the same control as in an application to court. And so you must accept that there is a lot of abuse because of the lack of control over the business rescue, where it commences by way of a filing of the resolution. Okay, I think that's where we now take a break. Let's say it's now, according to me, it's now 2 minutes past 10. Let's start at 10 past 10, if that's okay with you. So you can just stretch your legs so you don't get deep vein thrombosis or something. And then we will start again at 10 past 10. Thank you. Okay, ladies and gentlemen, we've had a 10-minute break. I hope you're all awake again and ready to carry on. We are now at study unit 4, the legal consequences of business rescue proceedings. Now, the most important consequence of business rescue proceedings, once the proceedings have commenced, is the moratorium on legal proceedings against the company. It is so important that in some countries, the process is actually, the rescue process is actually referred to as a moratorium, and they don't really have anything else. It's just a temporary moratorium on all legal proceedings against the company. And in most cases, in most jurisdictions, they try to make this moratorium as wide as possible, so that basically any and every type of legal proceeding against the company in their business rescue procedure is not allowed. It's only for a short period, but the point is that the business rescue process is often referred to as an opportunity to give the company a little breathing space, so that it isn't being harassed by creditors who want to be paid immediately, etc., and dragged off to court for all sorts of things. So to give the business rescue, the company and the business rescue practitioner, the opportunity to decide on the best way forward, what would be in the best interests of this company to get the best results. Now, so in most jurisdictions, as I said, all legal proceedings are excluded or are covered by the moratorium. In South Africa, because of the wording of Section 133 that deals with the general moratorium, it's not so clear what exactly is covered by the moratorium and what is not. Because the section says that no legal proceedings, including enforcement action against the company or in relation to any property of the company or lawfully in its possession, may be commenced. Now, I had always assumed that the reason why they added the company's property or lawful in its possession was just an effort to make it clear that everything was included, that you cannot say, well, this is not a legal proceeding against the company, it's about property or whatever. However, this provision immediately caused problems in interpretation because it has not been worded or made very clear. So the first question was, what would be covered by legal proceeding? Again, you see liquidation proceedings previously, now we've got legal proceedings. What would be included in legal proceedings? And you will see in your textbook, I think more or less the first case that dealt with the Section 133 was that the LA Sport 4x4 outdoor, where they argued that enforcement action would include cancellation of a contract. I think that was a bit of a stretch, and for obvious reasons, the court quo actually said, yes, you're right, cancellation of a contract would be included, but the decision was taken on appeal to the full bench of the High Court, and there it was decided that cancellation of a contract is definitely not a legal proceeding or an enforcement action. And this was confirmed then by the Supreme Court of Appeal in the Clutter-Murray case, where the court said legal proceedings would be proceedings in a forum. So it's really some sort of legal procedure in a court or the equivalent of a court. So that, of course, then the other problem was, okay, the next question was then where the Act states in any forum, what would be covered by a forum? And the courts have so far clarified that it would cover arbitration proceedings, and CCMA proceedings, because that's also a forum, and then of course any court. But we'll get back to that because you will see there has now been a complication on that. The next question was, what legal actions are covered? All proceedings against the company, as would be the case in most other countries, or only certain proceedings. So we have a case in your study guide, Kitera Court versus Le Rendezvous, where the court said, no, it's not all legal proceedings. It's legal proceedings against the company, or it's against the company's property, or it would be against property lawfully in its possession. Now, since you are able to cancel a contract with a company in business rescue on the same grounds that you would be able to cancel this contract if the company is not in business rescue, the moment you cancel, you validly cancel a contract with a company in business rescue, that company is no longer in lawful possession of your property. For instance, if it's a rental contract, a lease contract, then you have every right to recover your property, and it's not covered by the moratorium, so you don't need the permission of the business rescue practitioner or the court to institute those legal proceedings, because it's not covered by the moratorium, because it is not against property lawfully in the possession of the company, it's property in the unlawful possession of the company, and so you may reclaim your property. Now you will see on page 279 of your textbook, there is a statement that where the court said in Kitera, it's unnecessary for the applicant to seek leave of the court to institute proceedings for return of the property or to obtain an eviction order because the property is no longer in the lawful possession of the company. And then the textbook said, however, this is not correct since the moratorium applies to all legal proceedings. Well, it does not, unfortunately. We now have a Supreme Court of Appeal judgment, which I will tell you about in your tutorial letter 103, Timasani versus Afrimit Iron Ore, where the Supreme Court of Appeal held that there's three instances of the moratorium against the company, against its property or other property in its lawful possession. These are three separate things. So not every legal proceeding against the company is covered by the moratorium. And if the company is in possession of somebody else's property and it's not in lawful possession of that property, for instance, where a contract has been cancelled, then it's not covered by the moratorium and you do not need leave of the court to institute legal proceedings to reclaim your property. You can just go ahead. In this case, it was a deposit that was paid on a sale that didn't go through, and the contract very clearly said that if the sale doesn't go through, then the deposit must be returned to the purchaser because it remains the property of the purchaser. And the court said, well, it's not covered by the moratorium because it's not in the lawful possession of the company anymore because the contract has been abandoned or cancelled. Right, so now we know the moratorium actually applies to three different situations, and if the company is no longer in lawful possession of another person's property, then it's not covered by the moratorium and you don't need the consent of the practitioner or leave of the court to institute proceedings for the return of your property. Then the next question then was, okay, but in those cases where your legal action or legal proceedings are covered by the moratorium, To obtain, obviously, in most cases, the business rescue practitioner will not give his consent for you to institute legal proceedings, and you will have to apply to court. The question is, must you first apply to court, get the court's consent or leave to institute proceedings, then go back to court and actually institute the proceedings, or can you do it in one go? So in other words, in the same application, you apply for leave and you also apply for the relief that you want in the main legal proceeding. And again, because the court is not, the act is not clear, the courts had a conflict of opinion, and this is still an uncertainty because we don't have anything by the Supreme Court of Appeal on this matter. There is the Elias Mechanicals case, which was mentioned in your study guide, where the court said, sorry, you have to apply for leave first, and then if we give leave, if we allow you to institute your action, then you have to come back with your main action. Now, in this case, the applicants didn't even want money or something or property. They just wanted information from the company in business rescue, and the court still held that you have to get leave first to institute the action and then come back with another application for your main action, your main relief. But there were other cases, Safari Thatching, where the court held that if everybody is already before the court because there are currently there are liquidation proceedings, you don't have to come with a separate application for leave. In BP Southern Africa, which I thought was the most reasonable decision, the court said, well, in order for a court to decide should we grant leave to institute proceedings or not, we basically need to know what the nature and this of this main application or main relief is, what that you are looking. Have you got a case or not? If not, then we won't give the leave. But we need to know what the nature of your action is that you want to institute. So it would be more logical to have it in one application. In other words, you apply for leave to institute the action, and you also institute the action at the same time with your affidavit or other supporting documents to show what it is you're looking for, and then we can decide should we grant leave or not. In Boysen versus Jonker, the court was a little bit ambivalent about this, but then said we must keep in mind that it is a constitutional right to have access to the court, so we should limit that as little as possible, but it would depend on the circumstances. We recently had a case, Nathan versus Nathan, dealing with that was in KwaZulu-Natal. And first of all, the court said, the first question is, does the moratorium also apply to actions dealing with the process of business rescue itself? In other words, if somebody wants to apply for removal of the business rescue practitioner, or to force the business rescue practitioner to hold a meeting of creditors, or to draft a rescue plan, would that also be applicable? Now, many years ago already, there was a judgment which said this moratorium is obviously not applicable to court actions dealing with the business rescue itself. There should be. Is there anybody else who doesn't have sound?
I can hear you.
That's okay. Fine.
Yeah, no, then it's just the one person that doesn't have sound. So the problem must be with you. Okay, so in Nathan versus Nathan, the court said, well, this issue was not, or rather, counsel on both sides appeared to assume that the moratorium does apply, in spite of that judgment many years ago. I don't think anybody was aware of it because nobody mentioned it. Then the court said nobody raised this question, so we will assume that it does apply to all to business rescue actions as well. No, it looks as though everybody else has got sound. No, missing. I think you're the only one without sound. So you have to look for the problem on your side. Okay. They have people in lead as well listening to the sound, so they will also tell me immediately if there is no sound. So the problem is not here. Okay, so the court said, well, we will assume that it's applicable to court actions dealing with business rescue itself. But the court recognized that there are conflicting opinions. I don't think it should be applicable, because you shouldn't have to apply. If you're an affected person, you are given the right to be involved in any legal proceedings regarding the business rescue, and you shouldn't be required to get permission or leave of the court to institute an action or to make an application or get involved. So I don't think that's correct, but I don't know why the council simply assumed that the moratorium would be applicable. I don't think that's the purpose of the moratorium. The purpose of the moratorium is to keep everybody else out, creditors and whoever, so that the business rescue practitioner can focus on the business rescue. Anyway, but so that is still uncertain. And then the other question again in Nathan was in Nathan versus Nathan, the old question, should you have a separate application for leave of the court and then institute the action once you have the leave of the court? The court was aware of previous conflicting judgments, and referred to the Booysen, the Jonker case. But unfortunately, nobody seemed to know about the BP Southern Africa versus Intertrans case, which I think was a more logical, reasonable judgment. So the court said, well, as a general rule, because in Booysen versus Jonker, the court was a bit ambivalent about it, and there are cases like Elias Mechanicals where the court stated with absolute conviction that you have to have a separate application. The court in Nathan versus Nathan also said, well, as a general rule, a separate application for leave of the court to institute an action is required unless the matter is urgent. And then went on to say, well, we also accept or referred with approval to the case of Arendse versus Van der Merwe, which is mentioned in your study guide, where the court actually set out a sort of a list of requirements. How do you test whether this moratorium should be lifted, and what are the criteria? And the court said, well, in your application for leave, you will have to set out basically that you comply with the requirements of Arendse Van der Merwe, because you will only get leave of the court if you can at least establish a prima facie case against the company. Now, that was basically what the court said in BP Southern Africa. That's why you have to have a combined application, because then you can set out your case, and the court can then decide whether you have a prima facie case or not. On the other hand, one can understand why the court wanted, some courts want a separate application, because if your application for leave and your application for the main relief, if they are combined, then you basically have to go into you have to prepare for the main application, and that will involve costs. And then if the court then says, and for the company, for the business rescue practitioner, because they have to set out why they have to defend themselves against the main application. So if the court then decides, no, we're not going to grant leave, that would be wasted costs for the company in business rescue, where money is already short. So they don't really want the company to have to go into all these costs to prepare for the main application before the court has decided whether it's going to grant leave or not. So there's an argument to be made on both sides. But here, since we don't have a Supreme Court of Appeal judgment, we'll have to wait until the Supreme Court of Appeal has to decide on this, and then we'll know for sure whether a separate application is needed. Okay, I've already mentioned that arbitration proceedings are included in the moratorium because it's also in a forum, and you can go to court with an arbitration and have the arbitration decision or the arbitration reward made a order of court. Now, originally, there was uncertainty about whether the moratorium will also apply to actions in the Labour Court and the Labour Appeal Court and the CCMA. There was some confusion and conflict of opinions, but eventually the Labour Court itself said, well, you know what, the definition of court in Chapter 6 only includes the High Court. It does not include the Labour Court or the Labour Appeal Court. So we don't think that we have the authority to lift the moratorium or to hear a case. It has to go to the High Court. And that was more or less then the accepted principle in Shiva versus Uranium, or Shiva Uranium. The court said we cannot even give you permission to lift the moratorium because the Labour Court is not included in the definition of court in Chapter 6. However, we all know that the Labour Court and the Labour Appeal Court are very jealous of their authority and their jurisdiction. They guard it with everything they've got. So, as was to be expected, we had a complication there, and that was in the South African Airways case versus National Union of Metal Workers. Now, there it was argued that the Labour Court had no jurisdiction based on the previous cases and arguments. The Labour Court decided that they did have authority, although they're not included in the definition of a court, because they said this matter deals with Section 189A(13) of the Labour Relations Act, and it's our job to supervise that procedure. So if an employer does not comply with these requirements, and so the moratorium does not apply. And that was indeed confirmed by the Labour Appeal Court. I don't think that's correct, but that's just my opinion, because it is a legal proceeding. The Act does not limit the type of legal proceeding. It said a legal proceeding in any forum. This is a legal proceeding, and it's a forum because it's a court, the Labour Court, the Labour Appeal Court. So I would think that the moratorium should apply to the Labour Court and the Labour Appeal Court as well, because that's the purpose of the moratorium, to keep the company out of court cases, so that the practitioner doesn't have to fight a lot of court cases on the side while trying to work out some sort of a resolution of the company's problems. That should be a focus should be on the business rescue, and that's why it's only supposed to last for a limited period. So in that period, there should be a breathing space. The company shouldn't have to spend money on court actions. It shouldn't be taken to court for all sorts of issues, so that it can concentrate on the rescue process. And I don't think the fact that it's the Labour Court makes any difference to that situation, but the Labour Appeal Court has now decided. Now the problem is, of course, where do you draw the line? And that's going to create a problem in future. Which sections of the Labour Relations Act would not be covered by the moratorium, and which actions would be covered if people start demanding payments of salary under the Labour Relations Act? Does that mean the moratorium does not apply? So I think that they have created a problem for the business rescue proceedings, which are going to come back with other problems that we'll see in future. But anyway, that's how it is at the moment. So there's not much we can do about that. Protection of property interests. I don't think I have to deal with that in too much detail. The important part of that one is Section 134(3) that protects the rights of secured creditors, because there have been many attempts at getting hold of by practitioners or to using assets that are secured in favor of a pre-commencement creditor to try and get to use the proceeds of such an asset for the business rescue, especially if there isn't much money otherwise. But the courts have again and again referred to Section 134(3) to say it's very clear that the rights of pre-commencement secured creditors are protected. So you cannot touch their security unless you have their permission. And therefore, Section 134(3) provides that you cannot sell the asset secured by a claim of, in other words, that carries security or that secures a claim, unless you either have the consent of the creditor or the proceeds will be enough to pay that debt. Now, obviously, if it has to be enough to cover that debt, then obviously it means you have to then pay it over to that creditor. You have to pay the creditor. But you'll see in that Energy Drive Systems versus Tin Can Man, which is mentioned in your study guide, in this case, they try to argue that the proceedings of the sale were enough to cover this debt. The fact that the practitioner didn't pay the creditor, that's beside the point. The Act merely requires the proceedings to be enough, when you sell the asset. The court said, no, that's not how it works. You have to actually pay the creditor. You have to use that money to pay the creditor. You can only keep whatever is left after you've paid the creditor. So in this case, the original owner could still reclaim his property because there was a reservation of ownership. Okay, so that is fairly clear. Then post-commencement finance and the ranking of claims, there was a lot of conflict of interest and arguments and scuffling because, of course, you want to come as close to the front of the queue as possible. The idea behind Section 135 was to make it a little bit easier for a company in business rescue to obtain post-commencement finance, because you need money. Usually there isn't much money left in the company. You need money to pay your employees, to buy new products and so forth. In the end, I'm not sure if Section 135 actually made it any easier or just complicated the issue. It rather seems like the latter. You have quite a few cases about the ranking of claims, and we're talking about post-commencement claims here. And Section 135 is drafted in such a confusing way. Instead of saying, okay, first in the queue is the business rescue practitioner, and then comes post-commencement final, then comes the employees. They sort of mix it up. So you really have to concentrate to see now what exactly is the order here, which is why in the study guide, I've rearranged Section 135 to show you the ranking, which is the business rescue practitioner's remuneration and expenses. That's the first one in the queue. Now, because the Act is not clear at all about what would be costs or expenses of the business rescue practitioner, the South African Property Owners Association went to court and they said that if the company doesn't pay rent after commencement of business rescue, then those costs would be also costs of business rescue, because they're allowing the company in business rescue to continue using the property without being paid. Of course, they can cancel the contract, but if they don't, then surely the unpaid rental should be part of their costs. because they have to keep on paying rates and taxes and utilities. So they said, surely that at least must be included in the costs. The court held that it is not the case, because the costs that are referred to here are the costs that are specific to the business rescue practitioner and the business rescue proceedings. In other words, if the practitioner has to rent a hall to hold the creditors' meeting, or has to fly down to Cape Town to inspect some property, whatever. So it's only the costs of the business rescue practitioner in exercising his duties and his responsibilities that would be included in the cost. So the payments by the owner of a property for rates and taxes, that would not be included in costs, and that would be part of the concurrent claims in against the company, which goes right at the back of the queue. Now the Property Owners Association does seem to have friends in the right places, because there is an amendment to the Act that is being considered. Unfortunately, it's treated as a state secret, so nobody really knows what the latest version states. But the last version I saw was the 2019 version, in which a property owner, or in other words, a landlord who is not paid rent by the company in business rescue, but doesn't cancel the contract, will have a preference right for the rates and taxes that the owner pays on this property, and this will be regarded as post-commencement, as a post-commencement finance, really. It will be part of the post-commencement finances. In other words, it will be pushed, and it will actually be pushed to the front of the queue just after the fees and costs of the business rescue practitioner. Whether they've changed that in the meantime, I don't know, but there is actually an effort to give them a preference right, at least for the rates and taxes that they've paid. And not just that, they will also be given a vote on the business rescue plan for the amount of rates and taxes payable, paid by them after commencement of business rescue, which does seem to imply that other post-commencement claimants don't have a vote, but so they are specifically giving a vote on the rent. But you don't have to take much notice of that, because we don't know when this amendment will go through and what it will look like, because it's been changed at least, I think, 4, 5, 6 times now since it started. It's been going around since, I think, at least 2017. So anything could happen. Maybe they'll just drop it somewhere along the way, or maybe it will come through, or maybe it will be in a different form. But as things stand at the moment, the only costs and expenses that will go first in the row, to the front of the row or queue, would be the costs and expenses personal to the business rescue practitioner in exercising his duties. And then the next claim would be those of employees. Any payment that becomes due to employees during business rescue will be a preference claim, and it is regarded as post-commencement finance. I don't know why they thought it would be necessary to label it as post-commencement finance. They could just have said any claim by employees of post-commencement would be a preference claim, and it goes just after the payment to the claim of the business rescue practitioner. So there's no good reason why they should call it post-commencement finance, because obviously it isn't. Then there is also the case mentioned in your study guide of Diener, which I talked about, that Section 135 cannot dilute the rights of pre-commencement secured creditors. You'll see Section 135 doesn't say anything about secured pre-commencement creditors, and the court said it's clear you cannot use the proceeds of a secured asset that was secured before commencement of business rescue to pay any costs. Then National Union of Metal Workers versus VR Laser Services. The court was very upset that the practitioners actually told employees that they would that their post-commencement claims would enjoy preference over the pre-commencement secured claim of the bank, and the court went so far as to call them reckless to actually say or tell employees that they would have a preference claim, or rather that they would be able to use the proceeds of a secured asset, a secured pre-commencement asset, to pay their claims. So the court said that is absolutely reckless. Now that of course goes hand in hand with the fact that employment contracts may not be affected by your business rescue. In some countries it is possible, it's easier, becomes easier to retrench employees when your company is in some form of corporate rescue. The drafters of our legislation wanted to make it very clear that business rescue will not make it any easier. You will have to follow the correct procedure in terms of the Labour Relations Act. Also, that is, of course, is the indirect contrast to the situation in liquidation, because when a company is liquidated, all employment contracts are immediately and automatically suspended when the provisional liquidation order is issued, and then within 45 days after the final liquidator has been appointed, all employment contracts will automatically terminate. And the liquidator, if they want to retain some employees, they have to actually have a contract or an agreement with each individual employee that they want to retain. Otherwise, the contracts are automatically terminated. In business rescue, it's the exact opposite. Nothing happens to your employment contract, which is why in Richter versus Bloem Pro, the court also said that if the employment contract has been suspended by a provisional liquidation order, that employee is still an employee, although he's not being paid. The company doesn't have to pay him, but he's still an employee and he is still an affected person and can apply for business rescue. The court did not say what would happen after that 45-day period when all employment contracts are automatically terminated. There was one case where a group of people applied for business rescue, but after the company had been finally liquidated, and it was more than 45 days after the appointment of a final liquidator. But in this case, the court didn't have to consider this issue because the people, they lived in the area, they could not prove that they had actually been employed by this company that had been liquidated. So the court didn't have to decide whether they would still be affected persons. The court didn't even mention whether that was a consideration. It simply said, well, you couldn't prove that you were employees of this. It was a mining company, and so I cannot accept that you are affected persons. Okay, now we have another problem caused by the Labour Relations Act or the Labour Act in this same case of South African Airways versus National Union of Mine Workers. And here the court held that you cannot even start retrenchment proceedings or the process of retrenchment before there is a business rescue plan in which this retrenchment is stipulated. I think they were wrong because they interpreted the provision incorrectly. Section 136(1) B any retrenchment of employees contemplated in the company's business rescue plan. So they interpreted it to mean that if you want to retrench your employees, you have to wait until there is a business rescue plan. I don't think that's what the drafters of the Act had in mind. They were probably thinking of those jurisdictions where you can almost automatically retrench your employees without having to go through too much trouble and formalities if your company is in some form of business rescue. Because in, I would say 90%, if not more, of all business rescue cases, you will find that payroll is a very big expense, and it's one of the reasons why the company is in business rescue. It has too many employees that it cannot afford. We've seen that with South African Airways as well. They simply had too many employees. So what the drafters probably had in mind is you have to follow the procedures set out in the Labour Relations Act, even if your retrenchment is in an approved business rescue plan. They turned it around and said you cannot even start the process before that retrenchment or those retrenchments are contained in a plan. Now, as you know, a business rescue plan in a big company it can take months, it can take years before there is an actual business rescue plan, let alone whether it's been approved or not. So in that period, your business rescue practitioners are now unable to start any retrenchment process. They may not even talk to their employees or their trade unions about retrenchments until they have a plan in which they confirm these or in which they stipulate these retrenchments, which makes it very difficult for business rescue practitioners, because that's one of the ways in which you can save a lot of money for the company, is to get rid of employees that you don't really need, and where you can close down unprofitable parts of the business, but then automatically some employees will become redundant. They can't do that anymore. They also told me that they find that when they now approach the trade unions or the employees with retrenchment proposals, which have now already been indicated or stipulated in your business rescue plan, the trade unions tell them that you are not objective anymore. You've already said in your plan you are going to retrench us. You cannot come to us now and pretend that you haven't made up your mind and that we are still going to negotiate the retrenchments. You've already said you're going to retrench 50% of the employees. How can you say to us now, let's talk about it? It's already there. So there is already a negative attitude from trade unions, because they say you're not coming to us bona fide and with an open mind and objectively. You've already decided what you want to do. Now you pretend you're going to negotiate with us and talk to us about possible retrenchments. So in general, the Labour Court and the Labour Appeal Court has really complicated matters. Okay. Other contracts and agreements, I don't think I have to say too much about that. You will see that the idea behind the suspension, that the power of a business rescue practitioner to suspend contractual obligations from a pre-commencement contract, that was supposed to perhaps just give the company some breathing space, in that it doesn't have to pay on these contracts. It can suspend payment. But as you will also see in BP Southern Africa, it doesn't help much to suspend these provisions or these obligations, because the court there said that you still have, as the other party, the other contracting party, still has all the remedies, the contractual remedies that you usually have. So if it's a reciprocal contract, in other words, we're not talking about a breach of contract where you obviously can cancel the contract. This is now where you have a reciprocal obligation. So I am giving you the use of my property and you have to pay rent for it. If you are not going to pay rent for my property anymore, then you in terms of the rule of reciprocity, I don't have to make this property available to you anymore because I'm not getting your part of the contract, and therefore I can still make use of my contractual remedy by evicting you and actually cancelling the rental agreement because you're not meeting your part of the agreement, and most contracts, I would say, would actually be reciprocal. It's you give something and the other party gives something back. If they don't, then that in terms of that non-adem pleti contractors, you can cancel the contract and get an eviction order, for instance, if it's a rental agreement, because the other party, the company in business rescue, is not meeting its obligation. So it has a very limited use, I would say. Only the court can cancel an obligation. I actually don't know of any cases so far. Maybe there have been some, but I'm not aware of any major cases where a court agreed to cancel an obligation. And the court can, of course, set its own conditions for cancelling an obligation, which in the end could mean that there is still a claim against the company. So I'm not sure what the situation would be and whether it would serve any purpose to apply to court for cancellation of an obligation in a contract. Shareholders, they have a very limited role to play, although in broad terms they are giving the right to take part and be involved in court cases, etc. In most cases, they don't have much of a say. They can vote on the plan only if their rights will be directly amended or affected. Now, if the business rescue doesn't work, then obviously they will lose their investment. So I would say that they are basically affected in all cases, but the Act doesn't recognize that. So only if the rights of creditors are directly affected in the plan, they will have a vote. Otherwise, they are basically just standing on the sidelines and looking at this and what's happening, and they can't really do much about what is happening in the business rescue. So they are basically spectators for most of the part, or most of the time, as shareholders. Just be careful. Well, you don't have to be careful. It's so obvious that the drafters of the Act used the wrong terminology sometimes. You will see when you look at the definition of affected persons, it's very clear that they say it's shareholders. Your affected persons are creditors, shareholders, and trade unions, or employees who don't belong to a trade union. But then every now and then, the Act uses the term securities when they actually mean shareholders, because securities, the definition of securities also involves or includes debenture holders, but debenture holders are creditors of the company. They're not shareholders. They are treated like shareholders sometimes, but they are basically creditors, so they will have a vote based on their claim against the company for the debenture. So when you see securities, just take it to mean it's actually a shareholder. It's not a securities holder. Directors, there was a recent case where the court, I'll get to that later on about the fiduciary duties of directors, of the business rescue practitioner. Remember, the directors are still hanging around. They still have to fulfill their obligations. They still have to do their jobs, but they may not hinder the business rescue practitioner or sabotage the business practitioner, and they have to follow the business rescue practitioner's instructions. As long as they do that, they are actually protected against liability for most of the codified fiduciary duties and duties of care and skill, as long as they follow the instructions of the business rescue practitioner. And if the directors do something themselves which should have been done by the business rescue practitioner and which they had no authority to do, that action will be invalid. It will be void. That is the theory. In practice, of course, in many cases, the business rescue practitioners are involved in many cases, so they basically let the directors carry on with the job and then only look in every now and then. On the other hand, if they do get involved, we get the situation which we've had with the Gupta companies, the Oak Bay companies. We'll get to that later on when we talk about the business rescue practitioner. The business rescue practitioners were taken to court by the directors of all these various companies in the group. I think it was something like 43 times, because every time the practitioners did something that they didn't like, they would take the practitioners to court and ask for them to be removed or for an interdict, etc. The practitioners even had to get an interdict to be allowed on the premises so that they could get hold of the company's documents. So no, that's exactly what the moratorium tried to prevent. But unfortunately, this has to do with the business rescue process itself. And as I said before, I don't think the moratorium applies. So they had to defend themselves 43 times plus. I mean, that was in just about a year where they had to go to court for 43 times. Okay, just keep in mind the difference between creditors and independent creditors, and then also subordinated creditors. The courts have made it clear that subordinated creditors are only those creditors who have contractually agreed to subordinate their claims. That's usually shareholder loans and so forth. So your usual concurrent claim would not be a subordinated claim. Okay, I think that is all I am going to do this morning. So I am now going to give you the opportunity to ask questions about the study units we covered this morning. If you want to ask a question, remember to raise your hand, and I will then give you the opportunity to ask a question. So, any questions? Nothing at all. So everything is perfectly clear to you. I think if you read through your textbook and okay, please raise your hand if you want to ask a question. You'll see that little hand at the top here, there. So just click on that so that I can see you want to ask a question. Okay. All right, so you can ask your question, right?
This is Deirdre Meyer.
Yes.
I just had a question with regards to the PCF claims.
Yes.
In the event that the business rescue practitioner suspends the obligations, right, which she has the right to do, what happens in terms of a lease agreement? What happens to your claim post-business rescue if he suspends? Does it become in terms of ranking?
It's a concurrent claim. It goes right to the back of the queue.
And if they make an agreement, like we'll pay 50%, will that then be considered as a PCF claim?
No, it will never be a PCF claim unless, of course, they amend the Act. But at the moment, the PCF claims are very specifically only as stipulated in Section 135. So as a claim for rental would be a claim for damages, basically, also. And that goes, you only have a claim for damages, and it goes to the back of the queue because it's just an ordinary concurrent post-commencement claim.
So that makes claims for a rear rental, pre-business rescue and post-business rescue all concurrent?
Yes, I'm afraid so. Unless you've taken steps before a commencement to get a court order, but that as well. If you haven't cancelled the agreement, so even if you cancel the agreement, your claim is still, it's a concurrent claim. It's not a secured claim.
And what I'm hearing you say is rates and taxes, though, are PCF.
No, they're not. No, they're not. That's what the proposed this amendment to the Act envisages, but I'm not even sure whether that is still a thing, that amendment, or whether that section is going to be changed. But at the moment, it's not. It's all a concurrent claim right at the back of the queue.
Wow, okay. Thank you so much.
Right, any other questions? Right. Who's next? I don't see everybody's. Let me just see. Okay, it looks as though there's only one question at the moment. Right. I can't identify you because I can't see your name, but please ask a question.
Hi, good day. Could you please confirm the case law that you referred to earlier? There was a recent development where a lease agreement had been cancelled, and there was some sort of case law authorizing the landlord to proceed with eviction proceedings, even though
Yes.
there's a moratorium
Yes.
on.
The one case is in your study guide. That was the Kitera. What is it called now? Kitera property, Kitera Court versus Rendezvous. That was one. And then more recently is the Timasani case, which I will put into your tutorial letter 103, which you will get probably by the end of this week.
Thank you so much.
Okay, any other questions? Okay, I think if there are no more questions, I'm going to end the webinar now. Ms. Meyer, do you still have a question, or is your hand up from the previous one?
No, sorry, one last question. In terms of when business rescue actually commences, I know you said it is when the resolution is filed. I've read that many times, but when I look at the Act, more specifically, I think Section 132, it says that not only, and I want to know if my understanding is correct, not only must the resolution be filed with CIPC, but it must also be served on affected parties, and I think that's in Section 129. A notice must be filed, the notice must be published, and there are various dates that must be adhered to. If that is not followed, then your resolution lapses and becomes null and void, irrespective of whether you filed it with CIPC or not.
Okay, now you must make a difference between the filing of the resolution, which is when the business rescue commences. Okay. And then I talked about the various cases where there was some conflict of opinion, but that was where there was a liquidation proceeding, etc. So there were other complications. The Act is very clear. A resolution is of no force or effect until it has been filed. But once it's been filed, that's when business rescue commences. The other issues are procedural issues. In other words, where you have to serve a notice and on the company and notify affected persons, etc. Yeah. However, because of Panama versus Nell, where the Supreme Court of Appeal said, although Section 129 very clearly states in subsection 5 that if you don't follow the procedure, your resolution lapses and is a nullity, which would imply that the business rescue ends, because if there's no valid resolution, there cannot be a business rescue. The Supreme Court of Appeal said, no, that's not correct. Even if you do not follow the correct procedure and your resolution lapses and is a nullity, the business rescue doesn't end. Somebody, an affected person, has to go to court and ask for the resolution to be set aside, which is actually nonsense, because if the resolution is void and of no force and effect, there's nothing to set aside because there is no resolution anymore. But the court said, no, you have to go to court and ask for the resolution to be set aside in terms of Section 130, and then the business rescue will end. Now, I am convinced that it's wrong, because if you look at subsection 6, Section 129(6), you'll see it makes a very clear distinction. It says a company that has adopted a resolution may not adopt a resolution to begin liquidation proceedings unless the resolution has lapsed in terms of Section 5, subsection 5, or until the business rescue proceedings have ended as determined in accordance with Section 132(2). In other words, the Act makes a distinction between the case where the resolution has lapsed because of non-compliance with the procedure, and then it automatically ends, or you had to go to court to have it set aside on one of the grounds stipulated in 130. The Supreme Court of Appeal actually recognized that and accepted that the Act makes a difference between the two, and then basically said, well, we'll just ignore that. We feel that it shouldn't end, you have to go to court. So the one instrument really that the CIPC had to force companies to comply with the requirements of notifying everybody in time, appointing a business rescue practitioner in time, that has now fallen away. Now, the Supreme Court of Appeal's argument was that it could just be a small technical mistake, like appointing your business rescue practitioner a day late because there was something wrong with the licensing. Yeah. That happened in the days when a business rescue practitioner was licensed per case. So every time you were appointed as business rescue practitioner, you had to get a new license. That is not the situation anymore. You get your license for 3 years and then it expires. So that's not a reason why a person would be appointed a little bit late, apart from the fact that Section 6 of the Act very clearly allows you to substantial compliance in notification. So their argument does not really hold water anymore, but unfortunately we're stuck with it. And as I said, now people are abusing it, that for 18 months there wasn't really a valid appointment of a business rescue practitioner because he was unlicensed. So I could just as well go out and ask for my gardener to be appointed as a business rescue practitioner, although he doesn't have a license. And then I'll just hope nobody picks up on that until the plan is approved. And then I'll say, I'm sorry, but you didn't apply to court to have it set aside. And now it's too late because the plan has been approved. So it's a bit of a mess and it is being abused. And I do think that the Supreme Court of Appeal misinterpreted this provision. It should end automatically because it does if the if the board resolution is not valid for other reasons. For instance, you didn't have a majority vote in favor of business rescue on the board. You often find that in companies with only 2 directors. The one votes in favor of business rescue, then they think they've got a majority, which they don't. They need the votes of both. Or not all directors were informed about the meeting. Things like that. Then in terms of the Companies Act, such a board resolution, irrespective of what it was about, is not valid because it did not comply with the requirements of the Act for a valid board resolution. Then the courts have no problem in saying, sorry, there was no business rescue because there was no valid board resolution. But in the case of Section 129(5), where the resolution lapses, then all of a sudden there's a problem. Now they can't see it as the business rescue automatically not being valid because of Section 130. It's also, of course, due to bad drafting of the Act, unfortunately. So we're stuck with this problem. But I think that the Supreme Court of Appeal got it wrong. But as I say, unfortunately, if it's the Supreme Court of Appeal, if they decide that 1 + 1 is 5, we are all stuck with that. And we all have to base everything, and all of the divisions of the High Court will base all their have to base their decisions on 1 + 1 is 5. Whether they agree with it or not, whether they think it's very wrong or not, that's what they stuck with.
Okay, so what I hear you saying is, in terms of the Spolina case, that even though the resolution lapses, business rescue has still commenced if the resolution was filed with CIPC.
Yeah.
And it will be up to an affected person to have this resolution cancelled.
Yeah.
Even though they may not file another resolution for 3 months.
Yeah. So what would be the solution there if you really want the business rescue? If you don't want to, if the practitioner feels that he doesn't want to live with this uncertainty of maybe somebody will go to court and have it set aside, or maybe they won't, and you're not safe until the business rescue plan has been approved, you go to court and you say to the court, okay, I accept my business rescue, the business rescue resolution has lapsed, so please give me permission to do it over. So just cancel the previous one, set it aside, or whatever you call it, and give me permission to immediately file a new resolution to place the company under business rescue. In most cases, the business rescue practitioners just leave it and wait to see what happens, and going to court costs money. So most affected persons just accept that the thing will go, the business rescue will continue, even though there was something wrong with the procedural requirements. Before Panama versus Nel, there was a case, One Time Air Company. I don't know if anybody even remembers they existed, because they did not last. But in the One Time case, the business rescue practitioner realized that an important trade union, I think it was a trade union, was not notified of the filing of the resolution, and they just went to court because it's an ex parte application. You do it on an urgent basis. They went to court. They said, okay, our resolution is lapsed as nullity. Please give us permission to file a new resolution. Within 24 hours, they had permission. They filed the new resolution, and they were on their way with the business rescue.
Okay. Sorry, I don't know if anybody else got questions. I have one more question.
Yes.
The 4.2 protection of property interests. How does unperfected landlord hypothecs and general notarial bonds have an impact here?
Well, if it's unperfected, it means it's not effective yet, because you have to perfect it to give you that security. So you're not a secured creditor, so you are a concurrent creditor. You go to the back of the queue.
With general notarial bonds as well.
Yeah.
Because then, I mean, that makes the general notarial bond useless, basically.
Yeah, afraid so. Unless you have security, which would, for instance, give you a secured claim in insolvency as well, you don't have security. You're not a secured creditor, and you're not protected.
Yeah. Okay, thank you very much.
Okay. Right, any other? Just take down your hand so I can see if there's anybody else with a hand up. Is there anybody else who wanted to ask a question? Nobody else? There's still some hand up, but I'm not sure whose hand that is. Unfortunately, I don't know why, but no. Right, if there's anybody else with a question, I think you'd better just ask it, because I cannot, for some reason, see any who it is, if it's not one of the first people. Oh, no other questions? Okay. Okay, then I think we stop here, and we start again tomorrow morning at 9 o'clock, and then we will continue with. Okay, let me just see, is there oh. Okay, there's one question. Is it possible to get past exam papers? The answer to that is no, because it is an open book portfolio exam, which means that we may repeat questions, and so we don't give previous exam papers. It's not allowed at UNISA to give you access to exam papers if it's an open book, it's a portfolio exam. Okay, I think tomorrow I'm going to allow you to ask questions on the chat as well, because it looks like I can't see everybody who's got their hands up. So I'll have to change that. Okay, nobody else with questions anymore? Right, thank you very much, ladies and gentlemen. Then I hope you will be present tomorrow morning as well, when we do the second part of the study units. Thank you and have a nice day.